Filing for bankruptcy can sometimes help a business stay afloat. In certain cases, it can help the business not only survive, but thrive. If you're looking to file for bankruptcy with your business, the type of bankruptcy you choose will largely depend on the type of business you own, the configuration of the business, and the assets involved, as well as the amount of revenue available for a payment plan. When deciding if bankruptcy is the right thing for your business, consider the following factors. Is the business producing revenue? Consider closing down the business if it has been losing money consistently. Are your business's assets valued above all liabilities? If the business has assets that surpass the liabilities it holds while continuing to make a profit, the company may be worth saving. Are you responsible for any debts attained by the business? As a business owner, if you are responsible for any debts acquired by the business, it may be wise to keep the business open. The answer of which bankruptcy type is best for your situation depends on the type of business you have, as well as the value of the business's assets. Filing for a Chapter 7 bankruptcy as limited liability company or corporation, for the most part, filing for a Chapter 7 bankruptcy will determine the closure of the business. This applies to LLCs and corporations. In this scenario, the trustee will sell the business assets in order to pay the creditors, and the company will simply shut down. Filing for a Chapter 7 bankruptcy as a sole proprietor. While filing for this type of bankruptcy will seldom work to the advantage of a business, Chapter 7 bankruptcies could help a business owner if he or she can keep the business open if he or she is the sole proprietor who is providing a specific service. For example, freelance writing, accounting, or fitness trainers. This form of bankruptcy can benefit the proprietor because a bankruptcy trustee will be unable to sell the proprietor's ability to perform the service offered by the business. Filing for a Chapter 13 bankruptcy as a sole proprietor. It's important to recognize that businesses in the form of corporations, partnerships, or limited liability companies cannot file for a Chapter 13 bankruptcy. Chapter 13 bankruptcies can only be filed by sole proprietors. In the event that a business continues to produce a revenue, a Chapter 13 bankruptcy may be the best option. Filing for a Chapter 11 bankruptcy. The following types of businesses must file for a Chapter 11 bankruptcy to reorganize their debts while staying open: LLCs, corporations, and partnerships. Although not required, a sole proprietor may file for a Chapter 11 bankruptcy as well. Both Chapter 11 bankruptcies and Chapter 13 help the business stay afloat while configuring a repayment plan. However, Chapter 11 is more expensive and comes with more terms and conditions. Filing for bankruptcy can be a complex and frustrating matter. When considering a business bankruptcy, speak to an experienced bankruptcy attorney. He or she can guide you through the process and explain the best options for your situation.